It's Conduit News Radio with Paul Harrell.
All right, ladies and gentlemen, thank you so much for being with us. As always, good morning to you. And I want to start this segment by reminding you that it's brought to you by the Patriots of Act 746. They are on a mission to educate the people of Arkansas about your gun rights, open carry, concealed carry without a permit, constitutional carry, the decriminalization of carrying a weapon in this state has commenced, and it did so back in 2015. And here we are today. And last I checked, it's not the wild, wild west outside like the liberal left likes to claim. If you want to know more about the Patriots of Act 746, go to Facebook.com and search for Patriots of Act 746. Ask to be a member. It's a closed group, but it is a fast growing group. Here to talk more about that with the Patriots of Act 746, Mr. Chuck Clifton is back on the program. Chuck, welcome to the program, sir.
Good morning, Paul. Thank you for having me back.
Yes, sir. Now, let's start right there. I mentioned that the page is growing. It is just really exploding with members. And so are you involved at all with, new people that maybe hear this segment or they hear about Patriots from a friend? Are you involved at all with the educational aspect of this? You have people, I'm sure, that become a member of the page and have a lot of questions about what they can and cannot do. How's that going so far?
Paul, it's going pretty good. We're all directly involved with the new people. And anytime you have an influx of new people, it's people coming there to actually want to know what the laws are. And we try to educate them on exactly what the statutes are. With that said, I'd also like to remind all of our members that's on the page that to jump in and help out, and a lot of them do. There's some good people there with a lot of good information. And, we was all new to this at one time before 746 was passed, and once it was passed in 2013, we all kind of had to get educated. And once I got educated on it, then I wanted to educate others.
Yeah. I'm sorry. Yeah, you said 2013. Yeah, my apologies. It was 2013. You gave the wrong date earlier. So is there anybody that joins that just doesn't quite or is just amazed that you can open carry, or according to what the law says? And I know we had Tim Loggins on yesterday. He carries concealed without a permit specifically, to educate. I mean, is there anybody that just can't believe it because they have heard or they've been conditioned by the authorities to believe the opposite for so long?
Yeah. Sometimes there's people on there, they just can't believe that they've been told this. Indoctrination is what I call it, for so long. And whenever they've been told that for so long, it just takes more patience and more time with those type of people, Paul, to be able to educate them on what the law actually is. Mm-hmm. We encourage everybody to get involved, to ask questions. If they don't understand something, ask. We're more than happy to furnish them a statute with that. We encourage them to go read the law for themselves.
Yeah.
Once you read the law for yourself, it's kind of plain, and you can, it's kind of self-explanatory.
Yeah, it really is. It really is. I wish, some people in positions of power would kind of get on board with that, the plain meaning of the law. All right. Well, so
the ones in power would be nice if they would just read the law before they decided to pass it. In most cases, I think they just pass it. And we have to pass it to find out what's in it.
Mm-hmm. Yeah, that is true. We're talking with Chuck Clifton. Now, Chuck, one of the reasons there still is confusion, or let me just say this, there would be no confusion if there was a test case in court for this, Act 746 as it is now, and the new law. And so a lot of people have been wondering, that's never happened, because if you do get arrested for possession of a weapon under the old way or the old presumption, you got prosecutors across the state that have just dropped the charges because they know they can't get a conviction because of what the law says, because, hey, possession of a weapon in Arkansas has been decriminalized. But there is a case now up in or over in Greenbrier. Now tell us about that. You were at that hearing. Can you start over and tell us why there was a hearing?
Okay. I don't have the exact date, Paul, but a gentleman by the name of Kirby Ward was on his way home from work, which, by the way, he was on his way home from work from another county. And I'll get into that in just a little bit. And they stopped him for an expired tag. Mr. Kirby has relatives that are police officers. They had informed Mr. Kirby, if you are stopped while carrying your weapon, to unload your weapon and put it on the dash, in which Mr. Kirby complied. And as the officer was walking up to the side of the vehicle, he heard the slide action of the pistol. I can understand the officer's concern with the way times are nowadays, and Mr. Kirby definitely needed I would like to call a old-fashioned tongue lashing for that act. But being detained and charged with carrying a weapon would have been a option there. Yeah. But that's what he was charged with. He was charged with expired tags and carrying a weapon.
Okay. So that's the dispute. That's the dispute. And of course, according to what the law says, not only is possession of a weapon decriminalized, but he was also coming home from another county, which the journey provision would also apply in this instance.
You are exactly correct. And let me just just so I can remind everybody, Paul, let me read what the actual 573-120 says here. A person commits the offense of carrying a weapon if he or she possesses a weapon, knife, or club on or about his or her persons in a vehicle occupied by him or herself, otherwise readily available for the use with the purpose to attempt to unlawfully employ the handgun, knife, or club as a weapon against another person. Here is the defense for that, also in Mr. Kirby's place, because he did not have unlawful intent. This is what it says. Journey means travel beyond the county in which a person lives. Okay? Mr. Kirby was told that since he was working over there, the journey law did not apply to him, if you can believe that.
That's crazy.
Now, I've read this law over many a time, and I've read it over this morning because I have been known to miss something, and I cannot find nothing in here where it says anything about a journey law only applies if you're not working.
Yeah.
It says the person is on a journey beyond the county in which person lives, unless the person is 18 years of age or less. That's all it says about a journey. So where this police chief got that because he was coming home from work that he wasn't on a journey is, I would wish that chief could show me in this law where he found that.
Yeah, it's clear that this was an overreaction by the law enforcement, and this is another reason why we have such a problem, communication issue here. Now, the journey provision has always confused me anyway, Chuck. That's why just the normal unlawful intent, the burden of proof, I think that's the better way to go. The journey provision is confusing to me because what am I supposed to do when I come back into my county? Throw my gun out my window when I cross into my home county? That doesn't make any sense to me.
Exactly.
Which is why 5-73-120 essentially says, well, yeah, you got the journey law. We defined it. We've always had this journey provision, and they actually defined it with Act 746 of what a journey is. It was very ambiguous before, but beyond that, the rest of the act, I think the second section of the act goes on to decriminalize the possession of a weapon, whether you're on a journey or whether you're in your home county. It doesn't matter anymore. Am I right on that?
You're exactly right. Once the defenses, when they amended that law, Paul, they didn't take the defenses for carrying a weapon out of it. Under the old law, if you was on a journey, then that was a defense for carrying that weapon. Well, when they redefined what 746 or 573-120 was, they could have actually done away with all of the exceptions and not hurt the law at all, because in the very law itself, it does away with the defense.
Mm-hmm. So
if that makes sense.
Yeah, it makes sense. So we have a situation, though, where there was a hearing yesterday for this gentleman, Kirby. What's his name? Kirby what?
His name's Kirby Ward.
Kirby Ward. Now, you were at that hearing yesterday. What happened?
Okay, it was just a hearing. Mr. Ward went in and he pled not guilty. They reset his court date for a trial for August the 21st at 9:30, at which there'll be some of us that were attended. We'll be back over there for Mr. Ward. And I guess my assumption is I think they're probably going to drop those charges at said trial. I don't see how they can continue to charge him with carrying a weapon whenever the prosecutor, from the discovery and the things that I've found, that there's no way that he can prove beyond that Mr. Kirby had anything other than lawful intent with that weapon.
Mm-hmm. Yeah, he had the honestly, he had the officer's best interest at heart. It just didn't come across that way. Understandably so. It didn't come across that way at all. And
No.
So how does a prosecutor prove psychological intent? You know, you can't mind meld with this person. You know, you don't really know. So how do you prove that? And that's the whole point behind the decriminalization of carrying a weapon. And it's actually a huge transfer of freedom from the government back to the people. It's really exciting.
Yes, it is. And that right there, that just what you just said, you can't mind meld with them to find out what their intent was, is why prosecutors will not prosecute this. I've talked to several law enforcement officers, and they said, do you realize how hard it is to prove somebody's intent? I mean, you've almost got to just walk up to them and tell them, hey, I've got this gun, I'm going to go over here and shoot somebody.
Yeah.
Before they would even have cause to think you had bad intent.
Mm-hmm. Yeah. Yeah, or, I mean, you know, there's another scenario where, you know, maybe after the fact, you know, there's a social media post. Hey, I'm on my way to do harm to you, or a text message. I'm coming after you. You know, then you might have something. You might be able to prove intent there, but
Yes.
but those are circumstances are going to be rare.
Yes, and very rare. And in this case right here, the intent is just not there.
Mm-hmm.
I don't know what the prosecutor's thinking over there.
Well,
The prosecutor in the case name is Dustin Chapman.
okay.
He's the city attorney over there. And they had a substitute judge yesterday. The substitute judge's name was Brad Williams. And he was a lawyer filling in for the absentee judge. So
Interesting.
the substitute judge said that he would just hold this over for the regular judge.
Well,
and like I said, I don't see how this prosecutor is going to be able to prove this.
Yeah.
But whenever the regular judge comes back, they may just throw this out.
Well, so
Who knows? We're going to find out on the 21st.
yeah, and that's the
And
thing. So
if
is he incurring legal fees? I mean, how's Kirby Ward paying for this? I mean, I feel bad that he made a mistake. There was a miscommunication, and then now the officer overreacted, and now he's got to go through court proceedings, you know, and a waste of time for him, essentially, to do all this, and money. I'm sure it costs money to do all this stuff.
Yeah, I'm sure it does. He was appointed a public defender yesterday, so it'll be interesting to see what this public defender does, if this public defender actually looks at the law or if he just tries to make a deal.
Yeah, well, let's hope. Let's
I
hope.
would not encourage Mr. Kirby to take any type of deal. I would go ahead and take my chances in court. And even if he is found guilty at the district level, I feel that as soon as this appeal goes to the circuit court, it's going to be thrown out. It's going to be trashed.
Yeah.
Because it's just not there. The intent is not there. Not to mention, he was also on a journey, which is a defense for actually carrying a weapon. and he fit that to a T. He was outside the county, came back
Yep.
into his county of residence.
Here's
So,
the
I mean,
real
he's
question.
got double protection.
Here's the real question, though. It would really help if there was a test case. I mean, is there any I know it would also be. It's kind of hard to say this because it would also kind of waste the taxpayers' time. But if there was a pro Second Amendment prosecutor out there who realizes what the law really says and is tired of all this, this all just confusion and politicians fence straddling on what the definition of constitutional carry is and all this other stuff, it would be very helpful if there would be a prosecutor that would try to get a conviction, and you appeal it until somebody, you know what I'm saying? It would be helpful, don't you think?
Yeah. Oh, yeah. And Paul, there's a lot of us that's tried. So if anybody out there listening knows a prosecutor that'd be willing to do this, please contact one of the admins on the page, and we will set that up so that we can have a friendly prosecution and see if we can't get this thing put to bed and we can move on to something else.
Well, yeah, I mean, it's like I said, it's kind of, it's a weird situation because if a prosecutor's doing their job, they're not going to pursue charges when you can't get a conviction. And so, it's
That's right.
It's certainly a gray area there, but if you have our elected officials, okay, who have, are saying, like the governor says, we have constitutional carry, but you still have to have a permit to carry concealed. Well, he is redefining what constitutional carry is. So according to the governor's definition, we're actually not constitutional carry, but according to what the law says and what prosecutors are doing, okay, we are. But then you have law enforcement, and you have the Arkansas State Police. They want to keep their revenue. They want to keep people convinced they have to pay a permission slip fee and a background check and, get their rights sold back to them. It's a very messy situation. And what we need in this state, and we need this in so many areas, is leadership. And we're not getting that. And so we'll kind of see where the chips fall. Chuck, I'll give you the last word, sir.
All right, Paul. Yeah, that's exactly what we need and that's why you see this at a local level. It's not at a circuit court or nothing. It's in a district.
Mm-hmm.
And until we show these people that, look, this is what the law is, and the deputy prosecutors that would be at the next level let these district prosecutors know, don't do this. We're not wasting our time with it. You're just wasting your city's money.
Mm-hmm.
Until then, I think we may still end up seeing one or two of these cases every once in a while. But as far as I know, they've all been dropped, and I expect the same with this one. If not, it'll really be surprising, Paul.
Yep. All right, Chuck Clifton with the Patriots VAC 746. I appreciate it. Thanks so much for coming on the program.
Well, thanks for having me, Paul.
All right, you have a great day.